Why is FSA enforcement contacting me, and what is expected? Featuring Sarah Angelello, Supervisory Attorney Advisor, Investigations Group, Partner Enforcement and Consumer Protection, Maria Rodriguez, Director, Resolution and Referral Management Group, Jeremy Kim, Attorney Advisor, Borrower Defense Group, and Kristen Donahue, Chief Enforcement Officer.
Hi, I'm Kristen Donahue, the Chief Enforcement Officer at Federal Student Aid. I'm happy to introduce the Enforcement Office's first ever presentation at an FSA annual conference. Today, we will present our session entitled, Why is FSA Enforcement Contacting Me and What is Expected? Later today, you'll have an opportunity to hear from us again in a session entitled Enforcement Actions, What Should I Know? During these two sessions, you will hear from the four groups that make up enforcement: the Resolution Referrals and Management Group, the Investigations Team, the Administrative Actions and Appeals Services Group, and the Borrower Defense Group. Each group will talk to you about the work they do, the various forms of outreach they do, and what you should expect should you hear from them. First, I will give you a brief overview of the office and the work that we do. The mission of the Enforcement Office is to protect, empower, and seek justice for Title IV students and their families, while also safeguarding the public investment in higher education. Our office was elevated within FSA in the fall of 2021 in order to strengthen the oversight of the schools and their service providers and to take appropriate enforcement action where warranted. Members of our team review complaints submitted by students and borrowers, investigate suspected violations, take administrative action where warranted, and review and adjudicate borrower defense to repayment applications, more commonly known as borrower defense. The Enforcement Office focuses on significant violations of the Higher Education Act and its implementing regulations, violations that pose widespread risk to students and taxpayers. We work closely with FSA's Partner Participation and Oversight Team on a risk-based approach to oversight and compliance. We also coordinate with other state and federal partners to uphold student and borrower protection. Today's programming is designed to share more information about ways in which your institution might interact with the Enforcement Office. You will hear about student complaints, requests for information, action letters, borrower defense applications, and many other tools used by enforcement and FSA to do our jobs. I encourage you all to pay attention to the work we do. At the appropriate time, we share information about actions we are taking and the reasons we are taking them. This information can alert you as financial aid professionals to the problems that other institutions have had and issues the department is focused on. We've also issued several bulletins to highlight issues or trends from our work, not necessarily institution-specific, but relevant to the broader community. For example, when complaints and referrals suggested that some institutions were misleading service members by telling them that GI Bill funds would cover the entire cost of their education, when in fact they needed loans, we issued a bulletin to tell service members and schools to be on the lookout for this issue. We issued another bulletin after learning that former employees of some institutions believed they were prohibited from speaking to FSA about aspects of their job related to Title IV because of NDAs with their former employers. We told the schools that was impermissible under the Higher Education Act, and also shared the information publicly to ensure a consistent understanding among participating institutions. Our body of work provides valuable information as you strive to protect and uphold both the institution you work for and the students you serve. With that, and to get us started, I'd like to introduce Maria Rodriguez, the Director of the Resolution and Referral Management Group. Thank you.
Thank you, Kristen. Hello, my name is Maria Rodriguez. I am the Director of the Resolution and Referral Management Group within the Office of Enforcement. In 2015, President Barack Obama unveiled a Student Aid Bill of Rights designed to ensure affordable quality of education for all Americans and strong consumer protections for student loan borrowers. An important component of this bill was a presidential memorandum that called for the creation of a responsive feedback system that would allow student and loan borrowers an opportunity to submit complaints as well as provide feedback for their federal student loan servicers, lenders, collection agencies, and institutions of higher education. In response to this presidential memorandum, on July 1st of 2016, the department went ahead and launched the FSA Feedback Center that students today can access by visiting studentaid.gov/feedback. There, they're able to submit a complaint as well as manage any previously submitted complaint cases. The Resolution and Referral Management Group is responsible for the tracking, research, and resolution of Title IV compliance complaints, referrals, suspicious activity, and allegations concerning institutions that participate in the Title IV Higher Education Act programs. We primarily receive those complaints through the FSA Feedback Center. However, we also receive cases that are referred to us by the Office of Inspector General, the Office of Civil Rights, the Department of Defense, the Veteran Administration, and other oversight partners. We also work in collaboration with our school participation divisions, our investigations group, and other business units within the department to ensure that student complaints are properly addressed and reviewed for any implications that they may have on the administration of Title IV. And of course, we work with all of you. Whenever we are in need of information in order to respond to a student's complaint that we don't already have, we do reach out to you in order to receive that information. Our requests for information fall under the Secretary's authority pursuant to Article 34 of the Code of Federal Regulations, Section 668.14b4I. Typically, when we receive a complaint, we are going to review that complaint and any information that the student has provided to us. We are also going to review any information that we have available internally in our systems. So we do review our systems such as NSLDS, COD, and we're going to look at anything else that we have available to us in order to determine if a resolution can be provided to that customer. If we are not able to provide a resolution to that student with the information that we already have on hand, that is when we will reach out to the school in order to obtain information and records that are maintained by the school that are not otherwise available to the department. Some of those records may include, but are not limited to, student account details, ledgers, transcripts, enrollment dates if they haven't already been updated in NSLDS, as well as other pieces of information. Our request will come to you through an email. The email address will be customerservice@studentaid.gov, and we will send that request to the school official that you have listed on your e-app. When there is a change in officials at your institution, it is important that you notify the department in order for us to be able to properly reach out to the appropriate individual that will be able to timely help us in reaching a resolution for the student. In your response to the department, our request is that you would provide us with a narrative response that addresses the student's concerns, as well as any supporting documentation that supports your narrative response. It is important that if you are not able, for whatever reason, to open our request, or if there are any challenges that you are experiencing with our request, that you notify us by responding directly to the email that we sent you. Failure to provide a response to our request may lead to additional oversight activities at the department. So, one of the main challenges that you have communicated to us already is the encryption. Files need to be encrypted when they are being transmitted from the department and to the department, because we must protect personally identifiable information. The proper way to secure files is by utilizing a 256-bit AES encryption and providing a password of at least 12 characters long. It is part of your institution's administrative capability to make sure that your IT systems are able to receive, open, and send any files back to the department in a secure encrypted method. The department's preferred method of encryption is WinZip, and we will send you a file that ends in that .zip file tag at the end. When we send a request to your school, we will go ahead and actually send 2 emails. The first email will provide you with the request, the information that's been provided to us by the student, and the information that we are needing from you. The second email will provide you with the PII of the student in question that we're seeking information for. We understand that these requests can be time consuming, and responding to the requests of the departments definitely can be time consuming, but we thank you for collaborating with us in being able to provide an appropriate response to a student's concern. Next, you will hear from the investigations group.
Hi there, my name is Sarah Angelello. I'm a supervisory attorney advisor in the investigations group within the Office of Enforcement. The investigations group's job is to evaluate indicators of potential misconduct or high-risk conduct by post-secondary institutions and third-party servicers, and investigate institutions' compliance with federal laws, regulations, and the terms of program participation agreements. After completing our investigation, we make recommendations for appropriate action, which can include termination from the Title IV program, a fine action, conditions to be included in a school's program participation agreement, a limitation action, the assessment of liability through a program review or other means, a referral for a program review, a referral to another regulator or law enforcement agency, debarment or suspension for individuals, or no action at all. Some of the tools that we use in our investigations are requests for documents from other schools and other relevant parties, evaluating tips and leads that come into FSA in our tip line, interviewing students and employees, looking at online and other advertisements, and secret shopping operations. Our goal is to proactively identify and address major problems across institutions that pose widespread risks to students and taxpayers. Many people ask how investigations is different than the School Eligibility and Oversight Service Group, also known as SEOSG. Although there is overlap, the main distinctions are that investigations look at a smaller number of schools and generally focuses on certain types of violations. One of the things investigations focuses on is substantial misrepresentations. Our office was created in 2016 with people dedicated to reviewing these specific matters. Although investigations focus is on substantial misrepresentation, it also looks at all acts of Title IV noncompliance, so there may be overlap with SEOSG, and we have worked together on numerous issues with SEOSG. During the course of an investigation, we may want to request information from the subject of the investigation, or a third party with certain knowledge of practices, conduct, or services under investigation. Generally, a request for information, or an RFI, comes in the form of a letter to the school's primary contacts in our system and contains a few important parts. First, it will tell you that the investigation group has opened an investigation. Second, it will request answers to questions, copies of physical or electronic documents, records, or reports, or access to electronic systems and databases. Third, it will provide any relevant authority for the requests, which will generally point to the school's requirement to provide access to documents and personnel. Fourth, our RFIs ask a representative of the school to sign an affidavit stating that the response is complete and accurate. Although this is not signed under penalty of perjury, it does require the signer, on behalf of the school, to affirm that they understand any false, inaccurate, or incomplete information provided may result in action against the institution, subject to the Secretary's discretion. Failure to respond to an RFI can result in an administrative action relative to the violation. And lastly, our RFIs will set a deadline for a response, which we do differently based upon the number of requests or the complexity of the request. We understand that sometimes extensions are needed, and we will consider appropriate and reasonable extension requests as needed and warranted. Our goal is to proactively identify and address major problems across institutions that pose widespread risks to students and taxpayers. To do this, we also work closely with the Partner Participation Oversight Office within FSA. Although we generally use RFIs to seek information from institutions, there may be instances when a subpoena is needed instead. There isn't much difference between a subpoena and an RFI in terms of what types of information and documents are requested or how much time we give for the response. We also seek an affidavit signed by the school representative to indicate that the response is complete and accurate. There may be instances when the investigations group feels that it is necessary to come to your institution to undertake a site visit. During site visits, we may ask to interview employees, service providers, or students. We may request access to systems or ask you to print or provide electronic copies of documents. Pursuant to 66824, schools are required to cooperate with the request to make documents and personnel available. Next, we'll hear from the Borrower Defense Group.
Thank you, Sarah. My name is Jeremy Kim. I'm an attorney advisor in the Borrower Defense Group within the Office of Enforcement. The Borrower Defense Regulations require the Department of Education to engage in a fact-finding process before it adjudicates any applications. The fact-finding process is school-based. As part of this fact-finding process, the department notifies schools of borrower defense applications and provides schools with an opportunity to respond. During this presentation, I will discuss the notification and adjudication process under the 2016 Borrower Defense Regulation 34 CFR, Section 685-222. This presentation should help you understand your options and the applicable timelines if you receive a notice of a borrower defense application. I will also provide nuts and bolts information about the system Ed uses to send notifications and answer questions Ed has recently received from schools. Last, I will touch on the recoupment process, which is a separate process Ed may initiate if a borrower defense claim is approved. This separate process includes its own notification and response components. This information is also available in a recently published electronic announcement about the Borrower Defense School Notification Process. You can find the electronic announcement on FSA's website in the Knowledge Center. If you are watching this video live, my colleagues will put a link in the chat. If not, there is a link to FSA's Knowledge Center at the bottom of the next. As a part of the settlement reached in the Sweet versus Cardona litigation, the Department of Education is sending schools notice of borrower defense applications received from June 23, 2022 to November 15, 2022. The settlement requires Ed to adjudicate these applications under the 2016 regulation. That regulation requires Ed to notify schools of all applications before adjudication. The school response is optional, and there is no negative inference against the school or in favor of a borrower if the school does not respond. Let's talk about how notification works under the 2016 regulation. The 2016 regulation requires Ed to notify the school of the borrower defense applications filed by its former or current students and provide an optional opportunity for the school to respond before adjudication and to consider any response or submission by the school. The site for this is 34 CFR, Section 685-222, subsection E, subsection 3. This notification occurs prior to adjudication. Ed notifies schools by sending the school the borrower's application form. Ed's policy is to provide schools 60 days from the date the school receives the notification if they wish to provide an optional response. A non-response does not create an inference against the school, nor does it create an inference in favor of the borrower. This slide discusses notification timing. You may be wondering if you will receive one or several rounds of notifications. Most schools will receive only one batch of notifications from applications received by Ed from the June 23rd to November 15th, 2022 period. Over 90% of the schools receiving notices from this period have fewer than 100 applications. and barring technological or other unforeseen problems, the applications will all be sent to the school together. For the small number of schools that have over 500 applications filed by former or current students during this period, Ed will reach out and explain how it will pace the number of notifications sent each week. You may be wondering when your school may receive borrower defense notifications. The answer is that Ed anticipates completing the initial notification to all schools by approximately April 2024. This slide discusses adjudication. Taking a step back, the notification process is part of fact-finding, and fact-finding is a precursor to the adjudication in the regulation. After the notice period ends and the fact-finding process is complete, Ed adjudicates the applications on the merits. The 2016 regulation provides for approvals based on substantial misrepresentation, a non-default, favorable contested judgment, or a breach of contract. Substantial misrepresentations are the most common type of alleged misconduct. For substantial misrepresentations, Ed must have evidence that demonstrates that a borrower's school made a substantial misrepresentation that the borrower reasonably relied on to their detriment. The citation for the regulation is on the screen. Applications are approved or denied based on these elements. To meet this standard, Ed requires facts to prove each of these elements. These facts typically answer the who, what, when, where, why, and how questions relating to the alleged misconduct. If the application and other available evidence does not satisfy the regulatory standard, Ed will deny it and notify the borrower. If they satisfy the regulatory standard, Ed will approve the application, discharge the relevant loans, and may issue a refund of payments to the borrower. In some cases, if Ed approves a borrower's application, Ed may decide to engage in a separate process called recoupment, which we'll discuss next. If a discharge is approved, Ed will at a different date determine whether to engage in a separate proceeding to recoup the cost of the borrower defense discharge from the school. Schools will have an opportunity to contest any recoupment action before a hearing officer if they choose to do so. During that process, Ed will send a second notification to the school with the application form for all loans for which recoupment is requested, all attachments submitted by the borrowers, and the rationale for Ed's decision to discharge the loans. With this information in mind, we'd like to address some questions you may have. Does Ed conduct a substantive review of the applications before notifying schools? No, the 2016 regulation requires that Ed conduct fact-finding, of which school notification is a part, before it adjudicates applications. What should I do if the application is vague or doesn't have a clear allegation against my school? You have to decide for yourself how to respond, if at all, to any application. If you conclude that an application is vague or doesn't have a clear allegation against your school, you may include that conclusion in your response to Ed, should you decide to respond. When is the response deadline? Ed's policy is to give schools 60 days to respond. Does Ed grant extensions? Extensions are strongly disfavored and only granted in exceptional circumstances. What is the content of the notice? During the school notification process, Ed sends the borrower's application form and a notification email. Is an affidavit required? Borrower defense applications are submitted under penalty of perjury. Ed also requests that schools provide an affidavit if they choose to respond, but it is not required. What information should schools provide? Review the application and consider how best to respond, if at all, to the information in the application. Each application is unique and will require your review to determine what information would be helpful to provide. Under the 2016 regulation, Ed does not draw an adverse inference against a school which does not respond to an application. We are also here to help if you have any issues uploading your response or need assistance using COD. The 2016 notification letter includes information about how to receive assistance with uploading your responses to COD, or how to ask questions about specific borrower defense cases. If you have questions about how to use COD or how to upload your response, please contact COD School Relations at codsupport@ed.gov or 1-800-848-0978. If you have questions about a specific application, you can reach out to the Borrower Defense Customer Support Line at 1-855 279-6207 to speak to a representative. For additional information, you can also visit our website at studentaid.gov/borrower defense.